Welcome to the Law Shit You Should Know podcast. We're here to talk a little bit about the law
and a whole lot about nothing. Every week, we have a new guest to discuss current events, legal drama, and dive even deeper into
the Law Shit You Should Know. Hi, everyone, and welcome back to Law Shit You Should Know with Elyna Santana
and Leslie Marko.
And today we have the amazing Daniel Leyton with us. Hey, Dan.
Hi, everyone. Nice to meet you.
Dan, why don't you tell everyone what you do?
I am a civil litigator, partner with a firm called Kravitz, Talamo, and Leyton here in Coral Gables. I've been a practicing lawyer for, 25 years now.
Lies. Lies. You're not that old.
No, I'm as old as the hills. And the areas that I practice in are civil litigation, so disputes between business owners and corporate espionage and fraud claims and other civil litigation of that sort. And also I represent employers when they are sued for allegedly violating workplace laws. So
allegedly.
Always allegedly.
Always allegedly.
Always allegedly. So if they're alleged to not be paying their employees properly, if they're alleged to have engaged in employment discrimination, if they're trying to enforce a non-compete, if they're trying to defend against the enforcement of a non-compete, if they're alleging the theft of trade secrets, all those things are kind of in the wheelhouse.
All those employer messy
On
things.
the employment side.
On the employer side, yeah.
Works for the man.
Yeah. Yeah.
You're a corporate
woman.
Corporate crony. Okay.
Yeah. My heart lies. My heart politically lies elsewhere, but these guys pay pretty good. So. By the way, I love the setup here. I did not realize what this was going to be when I arrived today.
When I agreed to
I will
this.
say let me just say when I first agreed to do this, it totally escaped me. Although I think it was on the invitation that it was going to be filmed. So as soon as I realized it was going to be filmed, I said, guys, I don't know what your audience is like, but I don't know why you'd want to film me and chase them away. I don't know why. So since I've been here, I have been trying to control
the hair.
Yeah.
The hair.
Which is like a souffle. Which is like a souffle that's been in the oven a little bit too long. And I told them to use their best slimming filters to.
Well, I should tell you, and I think the one thing I didn't mention to you while we were prepping is that it's called Law Shit You Should Know, and that cursing is encouraged.
Oh, thank God! I'm really glad to hear that.
So please,
actually,
let your freak flag fly.
I'm really glad to hear that. And I will say the one thing when I've never done a podcast before, but I remember there's a television show called It's Always Sunny in Philadelphia, and on the show there's a brother and sister who are always bickering at each other. They own a bar together, and their dad, I guess, helps own the bar and operate the bar. So they're always bickering, and they're really funny when they're bickering. Their dad says, who's Danny DeVito on the show, and he says,
"Oh, that's hilarious!"
Yeah, he says, "You guys are so funny together. You ought to do a podcast." And they say, "Great idea." So they set everything up just like you guys. They set everything up. They have the mics out. They put something behind them. All of a sudden, the lights go out. The magnifying lights go on. They start the podcast, and they have nothing to say to each other.
No!
So they sit there dead air for like 3 or 4 minutes, saying a lot or whatever. So I'm hoping it doesn't go like that.
Oh, that doesn't happen here, Dan.
No, we have so much to say.
happen here, Dan.
Okay.
We have too much to say.
We are Latin women. We don't shut up.
Oh, man.
I'm sure it'll be fine.
Yeah. All right. So let's talk some law shit you should know, or at least
Absolutely.
our podcast audience should know.
Absolutely.
And I think you mentioned the first topic I want to talk about, which is non-competes, because I happen to know that there is a proposed rule to get rid of non-competes.
Yeah.
So can you tell everybody what is non-compete and what is this rule? And then I'm going to ask your opinion, but go on.
So non-competes are contracts that employers use with their employees or with independent contractors, which say essentially you are being exposed to really sensitive information, to our bank of customers, to our proprietary data, and because of that, and because of the platform that we're going to give you working with us, we don't want you to go down the street and immediately start siphoning off our business by using the materials we've given you through this platform. So,
Sure.
you
I've taught you all the shit you know.
Exactly.
You can't go use it somewhere else.
Right. So that's the basic idea behind a non-compete. I think the problem that some people have with non-competes is they are sometimes, remember I work for the employers, sometimes allegedly they are sometimes abused in the sense that sometimes an employer will give them to everybody. Now, I remember walking into a client's office who was under an audit from the Department of Labor, and the first person we see when we walk into the office is the receptionist. So all that person is doing is answering the phones, plugging the calls in, routing them to whoever the person is they're trying to reach. And I said, okay, well, let's start here. Does that person have And as we were going through a checklist of things, I said, a non-compete. And the guy said, absolutely she does. Okay, well, I mean, you know.
For all the specialized knowledge.
Exactly, right.
In.
Like a non-compete would be like appropriately given to someone who is an engineer at Coca-Cola and has learned the formula that has been
Kentucky Fried Chicken secret formula.
I didn't know they had a secret formula, but yes.
12 spices, Dad. 12
I'm not.
divisions.
I didn't know this, but you don't know that Trump's indicted. Like,
No,
no, we just did a podcast with someone
You
else,
didn't
and
know.
she didn't know Trump had been indicted. But
Four
she
times.
knows. But
4 times.
but
4
she
times
knows
now.
that there's 12 ingredients in this secret sauce.
That was the
okay?
commercial in my childhood. Thank you very much.
Okay,
The
well,
delicious Kentucky
okay.
Fried Chicken.
Well, let me take
original
Leslie's.
recipe.
We
There's
digress.
12
We digress.
herbs and spices.
Well, let me take Leslie's example. The person that has the secret guarded recipe for 12 spices in Kentucky Fried Chicken. The owners of KFC don't want that person going to. I
man.
don't know what a
Popeyes.
Popeyes. Fuck Popeyes.
Right, and Popeyes.
There's
Yeah.
a story.
And,
We're not going to tell the Popeyes.
and giving that information away. So what they do is they say, we're going to put a break on things. We're going to stop you from but that's like when the non-compete is being used appropriately. It's for a good purpose.
Right.
When it's used,
They're
in,
like trade secrets, right?
yeah.
Kinda.
Although trade secrets is its own field. Besides
Okay,
that,
okay.
you don't
I take
have
that
to
back.
have a non-compete. You know, in other words, the person that learns the Coca-Cola formula. Even if they don't have a non-compete, if they run down the street and they try to give it to Pepsi, they're still going to be liable.
Oh,
Okay.
interesting.
Yeah, that for sure, because
Under some common law theory.
well, it's a trade secret.
Okay.
I mean,
trade
a
secret.
company has trade secrets, and a non-competition agreement is like an extra layer, but you still can't go around giving away your company's trade secrets. You couldn't say, for example, well, I work for Coca-Cola and found out their most sensitive formula for Coke, but I didn't sign the non-compete, so I'm going to go sell it to Pepsi.
Yeah.
That you can't do. But that's the basic framework. An
Yay,
employee-
boo.
yeah, right. Yeah, it'd be profitable to try, but the idea is you get someone to agree that because you're giving them a platform and exposure and information and data that is sensitive and they wouldn't have otherwise, that when they leave you, they have to take a cooling off period where they can't come around and compete against you within a certain period of time, within a certain region, depending on the business and so forth. Now, the FTC, the Federal Trade Commission, has decided that is an abusive rule that is kind of stifling the economy. That the abuses associated with that rule are overriding the legitimate value of the rule. Or the
policy
of
kind of. I'm going to ask your opinion in a moment.
Well,
I'm not going to give it, but
I'm going to dance around a little bit. So what they've done is they proposed a rule that would make non-competes essentially illegal. And not only would they invalidate the non-competes, they would tell employers where there's a non-compete in place now that they have a certain number of days to go back and tell the people that have the non-competes that they're no longer valid.
Oh, you're not even like grandfathered in.
Yeah,
to,
no.
Okay, backdating the non-compete.
Right, and the thing is, with an agency like the FTC, so the FTC is an agency, it gets its authority from Congress,
Sure.
so it makes these rules.
And it has an enforcement arm.
Exactly, but now when it creates a rule or proposes a rule, it has to put that rule out to the public, and then it has to invite comments, because they want to say, look, we want to see the public's experience, we want people in the business sector and the employment sector to give us what they think about this. And so they got a lot of comments.
It's the rulemaking process. It happens
Exactly.
in my world too. This is how how things start happening.
Yeah, well, I don't know how many comments are typical for a proposed rule, but this one got a lot of comments. I think like 27,000, 28,000
That's
comments.
a lot.
And so the FTC...
That's a lot of public engagement.
Yeah, absolutely. The Chamber of Commerce was writing a lot of letters. And
I was gonna
so...
say, but this is very one-sided commentary. I mean, the receptionist isn't writing comments, guys.
No, but there
You
are...
see what I'm saying? These are businesses that are like, fuck you guys, I'm going to complain about this.
Yeah, there are advocacy groups on behalf of employees who have written. It's almost like an amicus. How cute!
That's adorable.
Listen,
That's adorable.
Let me stop.
Stephanie has an advocate.
Hold on, let me stop you. Let me stop you. It's not just employees though, right? I mean, there are people who are in non-compete agreements that maybe were an employee but went out and started a new business. So let's say that you have a Starbucks. You own a Starbucks. You don't own it. You're whatever.
You're a barista.
A barista. Fine, you're a fucking barista. And you decide I could do this, and I'm gonna open my own coffee shop. And you sign a non-compete with Starbucks. But then tomorrow you go open your little shop in the corner with your little,
your coffee
latte.
Yeah.
Has
Your
nothing to do with
cafecito.
Starbucks, but
Right.
you have your own brand of coffee now, whatever the fuck it is.
And you get a 27-page complaint.
That's
with
correct.
A 75-page
And I was
memo.
gonna say,
From Daniel Leyton.
and listen, guys, listen, the guy in the corner is not stealing Starbucks' clients, okay? Starbucks' clients are gonna go to Starbucks. Like, get the fuck out of here. Like, no one's gonna steal those clients, right?
Yeah.
And Starbucks cannot I cannot find it legitimate that Starbucks say that is a competition that's taking away their business. I don't find it realistic. I mean, maybe if we're talking about Dunkin' versus Starbucks, then we're talking same level, right? But like the guy in the corner. And so these people sign non-competes, and from the other side, like, I agree that it stifles business, because that guy would never go out and, like, become an entrepreneur, which is good for our local economy.
It's. I think it's a matter of. I agree. I think that the non-competes by their nature serve a useful purpose, but they can be abused. Look, I mean, there are instances where somebody says, I know this person that has left us didn't really have access to confidential information. I know this person that's left us doesn't really have any proprietary data. I know that they don't really have access to our secret contacts, but I want to decapitate them and put their head on a spear and put them out in front of the office as a warning to all the other employees. That does happen. And especially when it's just being used indiscriminately, that I think there's a reason to invalidate them. But there are legitimate reasons for non-competes. There are plenty of instances where somebody actually has access to serious information, and they might go across the street and use it. So, if the FTC, reading all these 28,000 comments, decides to kind of take a middle ground and say maybe a presumptive argument against the legitimacy of a non-compete, but you can overcome the presumption by showing that this particular, those things kind of exist in some form or fashion already, but you can strengthen them to some extent. Nobody knows where it's going to go. I mean, essentially, they were going to, the comment period closed in, I believe, March or April, and they were going to vote on the rule a few months after that. They have now kicked that decision out by a year. They're going to look at this in 2024.
Oh, wow.
And, what's going to happen is, if they do invalidate non-competes in private sector settings the way they're proposing to do, then you're going to see a lot of constitutional challenges. You're going to see the Chamber of Commerce sue. And, what they're going to say is,
you don't have the authority to enact this bullshit in every state.
That's exactly what they're going to say, yeah. Which is interesting because it gets into an area that could be a very significant ruling for a lot of other areas.
Yeah.
In other words, not too many cases, from what I understand, challenge whether an agency has been delegated the necessary authority to enact certain rules. Most of the time we say, okay, the agency has been delegated this authority. Here, the Chamber of Commerce and some other advocacy groups would step forward and say, no, the FTC was never given the authority to adopt these kinds of rules, and it's possible that the Supreme Court eventually, which is going to hear this case, assuming it gets filed, may say, okay, yes, the FTC has overstepped its bounds, it wasn't really given the authority to do this, but now if it does that, it's going to have an impact not only on that decision, not only on the FTC, but on a whole range of other agency decisions. So, it's kind of a case to watch for a whole variety of reasons. But I think the other point is that if the FTC eventually in 2024 goes ahead and adopts this rule or something close to it, it's going to be years before the matter is settled.
Yeah.
But, it's something to watch, because if you're an employer and you want to get your employees to sign something that gives you some level of protection, there are other things you can do. You can have a non-solicitation agreement, which says, it doesn't say that you can't compete against the employer, but it says you can't go poach the employer's clients, can't go poach the employer's employees, and so forth. You can do other things. You can try to, rather than a non-compete, you can try to claw back the cost of training of the employee. There are creative things. It is vicious. There are some creative things that employers can consider doing, even if the rule is enacted. Now, whether those things will be exposed or argued as being illegitimate or overreaching or whatever, that's all to be decided. But what happens with these things inevitably is people start talking about them early and figuring out what they might do, and this is going to go a lot of different places.
Is there any talk of shifting attorneys' fees and such such. I mean, it seems like for wage and hour, right?
Oh,
you
yeah.
weren't paid overtime, and now you have every shyster lawyer on the planet saying my client was owed 2 additional hours, and I get my $1 million in fucking attorney's fees for going to trial.
Oh, God.
Right? Is there any of that?
You know what's funny is Leslie and Ellie warned me that you could go off the rails in this discussion, and that's like right off the
I warned you.
No, right off the
That's a
off
legitimate question.
Well, no, it is a legitimate question. But let me say this: years ago, that
I warned you.
There are two big buckets in what I'm going to call small employment law. And by small, I used to work at a firm called Proskauer Rose, which is like
small little.
No, that's not right. No,
small little law firm.
That's not small.
Tiny.
No. Yes, two attorneys, Proskauer Rose.
Two guys in Hialeah.
Those guys do in Hialeah. Those guys do what I would call big labor law, which is they defend management on a broad scale. So yes, they do individual cases, whatever. They also do everything up to collective bargaining agreements. But smaller employment law would be basically into 2 buckets. There's a few others, but it's wage and hour law, which is what you just mentioned, and there's employment discrimination. Those are the two. And employment discrimination is a heavy lift. I mean, you've got to prove a lot of things. Cases are not easily won by a plaintiff's attorney.
Right.
Sometimes it's hard to find the right person, if any, to take that case. We defend against a lot of those cases.
But that doesn't mean people don't try.
Well, no, people try.
I mean,
Wage
people
and
try
hour
all
law.
the time.
Wage and hour law, which is what Leslie just mentioned. Wage and hour law.
Jefe no
That-
paga.
Yeah,
Billboard.
Jefe no paga.
Hello?
Yeah, Jefe no paga.
Like,
That is a hopping area, and
course.
it's because the law is written in a way that heavily favors the employees. And so you get a lot of cases. Now, probably less now, because the labor market is really good. People have jobs. It's less likely they're going to lose a job and go sue the employer. But, especially when the labor market is tight, it isn't so good, and people are losing their jobs and don't know that they're going to eventually be able to return. There are a ton of lawyers who will take those cases and specialize in those fields because there are all these presumptions that are written into the law. And I mean, you can understand the reasons why. I mean, in the real workplace, the theory is the employer has most of the power. That's definitely true. You will have employers that will collect all their employees together and stand over them and say, guys, I have overtime work to do this weekend, but I'm telling you right now, I do not intend to pay time and a half. If you want to do the work, I'm happy to. If you want to do the work, we have the work for you, but this is all I'm going to do. Who wants to do the work? And of course, people raise their hands to do the work. So in the workplace, the employer has a lot of power.
Where do I get those people? What are you talking about?
I'll see if I can find it for you.
I have yet to see that.
But now, in the workplace, the employer has a lot of power. When the employee leaves, now let's say the employee raises their hand and says, okay, I'll do that work. They do the work for the weekend. They get regular straight pay. They don't get time and a half. And then they leave the job the next day and they sue. Who wins? The employee every single time. Because now the law says that once you get away from the employer's inherent natural power in the workplace, we're going to make sure that the law favors the employee and levels the playing field. And so there's also other things. You mentioned attorney's fees. That's exactly what it is. You as a plaintiff can win almost a small de minimis amount. You can win $1,000, $2,000, and you will be entitled to your award of attorney's fees. The defendant, even if they hold you to essentially a zero verdict, if they prove they didn't fail to pay you what you were owed, they're not going to get their attorney's fees back. By the way, as a practical matter, they're not going to get their attorney's fees anyway because it's hard to collect attorney's fees in that situation.
Right, yeah.
But so you will have a situation where it is bad to begin with, and it just keeps getting worse if you're an employer. I think a lot, and the reason that you see a lot of law firms in that area is because it's almost like fish in a barrel. Because a lot of employers do it wrong, all the way up to law firms. A lot of employers do it wrong, and as soon as they do it wrong, somebody can jump in, make those arguments, and they just have to keep litigating. And every hour that they spend as a lawyer eventually becomes an hour that they'll get paid in a settlement. And so if you're the employer, it's a bad situation that just keeps getting worse.
Yeah,
keeps getting worse. I don't know how we got on that topic, but that's the general story with those two types of
it
things.
shifts that kind of, I can go get a lawyer and they're going to take my case and they're just going to go to town like a dog with a bone.
Yeah.
If you shift those attorney's fees.
I don't think it's going to be, I don't know what they're going to do with this proposed rule. I mean, there's a lot of comments out there, and they may go anywhere with it. But whatever they do, there's going to be a lot of legal issues that erupt from it. Now, whether it means they're going to shift attorney's fees, that I don't know. But let's say they do what they originally intended to do, which is to say in the private marketplace, for the most part, with some exceptions, non-competes are going to be extinguished. We're going to get rid of them. you will see employers try to do some of the things that I mentioned. You're going to see employers like lean heavily on non-solicitation rules. You will see employers try to say, well, we spent $10,000 training you, we expect those $10,000 back. You will see all kinds of tactics, and that will invite lawyers to the field. So you're going to see for years, and of course there'll be the basic challenges to the legitimacy of the rule to invalidate the non-competes. And you'll also see a lot of people come back and say, well, the rule was adopted, and part of the rule is that if you're an employer that has employees with non-competes, you're supposed to, within 60 days, alert them that the non-competes are now invalid because of the new rule, and you didn't alert me. So whatever consequences that brings. So there's going to be a lot of activity around this. It is going to be a hotbed of legal activity, unless, of course, next year they say, we're going to kick it to 2026.
Fuck it.
Just kidding.
Just kidding. They might. They absolutely
might.
might.
We don't have this right now.
Yeah,
So,
you never know.
Now, I want to come back for a second because you mentioned law firms, and yes, we can be culpable too. But lawyers can't sign non-competes, right?
Lawyers can't, but their staff. Oh no, lawyers can't sign non-compete. Absolutely.
Yeah.
Right.
I was about to say, I remember looking this up at some point.
And the answer there is we take care of our own. That's
and
exactly
we take care of our own.
Right.
So the lawyers write the law, and so we take care of our own. Everyone else, fucked. Right? Is that a good summary?
For the most part.
We got it.
Yeah.
All right, so let's keep talking about shit that goes wrong with the employees, right? So what about, can I have you waive rights when you leave? So you can't compete with me, but I can have you waive this lawsuit. So let's say, you just mentioned how people are suing
this
their
money,
past
you
employees.
can't sue me.
Right, like I'll give you $1,000 and you don't come back and get me, right? The concept of severance.
Yeah. So like a severance agreement is when an employee is departing. The employer says, well, we would like to just walk away from each other. Mm-hmm. We don't want to have to worry at night that the employee might come back and make a claim for race discrimination,
whatever the fuck it is,
pregnancy discrimination, whatever it may be. So what we're going to do is we're going to offer the employee. Can I fire a pregnant employee? You can, yes. I get this question a lot. You can. Anyway, yes.
We'll get back to that.
We'll come back to that.
Put a pin in that one.
Back to this.
Put a pin in that one. So an employer may say, look, I don't want to have to worry that I'm going to get sued down the road by an employee. So what we're going to do is we're going to offer that employee some money that we do not owe them. And in exchange for giving them that money, they will sign a document that says every right that they may have against us that can be waived will be waived. So, and there's a whole bunch of rules and procedures that fly up around that concept. You have to give them a certain period of time to consider it. You can waive that time. You have to give them a certain period of time after they sign the agreement to revoke it in writing. That is a non-waivable period. You may have to give them 21 days to consider it. You may have to give them 45. There's a whole bunch of rules that come along with this.
Okay.
But one of the things that employers like to stuff into severance
I take offense to that terminology.
Stuff into it?
I don't stuff anything.
Fair enough. I'm sure you know.
You're my employment lawyer, Dan. You would know. Don't
One of the things that severance agreements sometimes include is a confidentiality provision and a non-disparagement provision. So in other words, it may say, look, you're not going to go telling everybody about the terms under which we signed this severance agreement. You're not going to go disparaging us, right? We're going to hand you these few $1,000s. You're not going to go around, besmirching the company and running it down to all the other employees. So that's like part of the bargain. And, a lot of employers, understandably, and one thing I've always learned is that the line separating employees from employers is a lot fuzzier than people think. Like there's an impression that employers they have the handlebar mustaches and they're cracking the whip. But a lot of times the employers are folks that just know their industry, they've worked hard, and they've crossed the line from being employee to employer, and they're well skilled in the fields that they are working in, but it's not like they have studied the nature of management and now they are trying to catch up to the particular industry. It's the reverse. Yeah. So a lot of them just, they would understandably say, well, listen, if I'm going to give you $5,000, $10,000, $20,000, $2, whatever the amount is of the severance, because it can be almost anything. If I'm going to give you that money that I don't otherwise owe you, I should expect some confidentiality so you don't go running around talking about this and that you don't go running us down. I wouldn't pay you the $5,000, $10,000 if I thought you were going to turn around the next day and say, hey, this is a terrible place to work, it oppresses employees. Yeah. So it's a reasonable thing in a sense for an employer to want. But the problem is that there is a broad law called the National Labor Relations Act, NLRA, and it gives employees rights. And again, there are my heart is in one place, my business is in another. But the idea behind it is you should encourage people to be able to talk about what it is that they do, what problems they have on the job. You want people to be able to talk to each other.
I mean, does that work both ways?
Can the employer run down the employee? Sure.
Okay.
Sure. I mean, they may be liable for it.
Probably not a good idea.
They may be liable for it. But,
They may be liable for it.
you know, but for example, and you can
It's
see
a
this.
great way to get sued.
Yeah. You can see this playing out in a lot of ways. Like, for example, if somebody stands up at a meeting two people stand up at a meeting, they walk out in protest over what the employer is saying, that could be considered communicating messages on the terms and conditions of their employment. And so there is a provision within that law, the NLRA, that says, it's called Section 7, and it says that people are allowed to talk about what happens on the job, talk about the terms and conditions of their employment. Obviously, that's oversimplifying it, but that's basically the idea. So, recently, the National Labor Relations Board, which is the arm that implements and oversees the NLRA, it got a case dealing with this issue. And what it said was, look, when you include in your severance agreement something that says you can't talk about this, and you can't go running down the employer to other employees, that is a violation of the employee's right under Section 7 to talk about the terms and conditions of their employment. You can't stop an employee from going to somebody else and saying, hey, you know, this is a bad place to work because, you know, this has happened on the job or that's happened on the job.
You know,
So,
I'm a business owner now, but I'm not going to lie. I've worked for others before that, and who
Right.
hasn't done that? Like, don't
Right.
go there.
Who
doesn't talk shit about their former employers? I mean, for God's sakes, I'm in an office with 17 people. They all talk shit, including myself, about our former employers.
It's an American institution.
It's
We're
the
right.
American way!
We're running against Labor Day. Yeah. It's Labor Day's Monday.
I mean, we're gonna celebrate, you know?
So,
No, but I wanna flip this on its head for a second.
yeah.
Because, right, every time you fire someone, right, and usually you fire them for very good reason.
This happens often, doesn't it?
It happens often.
With cause.
With cause. And then you start getting calls from potential new employers that this person is.
Yes.
And sometimes these people are so lacking self-awareness
That they write you
they
as a
are
reference.
stupid enough to say, of course you can call, allegedly. You're my previous
Supposedly.
employer. Supposedly. And the other thing is that Miami is this fucking big.
Yeah, I mean, we are in South
So
Florida.
you
where
start, not only is Miami this fucking big, but let's say the immigration bar
even
is
smaller.
even this fucking, and everybody knows Elyna, she's a connector.
I know.
Oh, you know?
I know. She's like a big boss in the
I
city.
mean, she knows everybody.
I know.
Everyone is gonna call Elyna and go, Oyeme, Fulanita says
that
that
hey,
she worked with you.
This person worked with you, and
And she says that she was fucking employee of the month, this bitch.
Yeah, she was your best employee.
She's your best employee.
Yeah.
And
And
you
do
were
you just-
crazy.
and do you just
You
rip the
had
ball
to
out?
scale down because your
No.
business is doing so bad. I kid you not.
Yes.
Yes.
I have at least 2 people who have told other employers that
Right,
they were
'cause of
laid
course-
off for lack of work.
How cute.
Laid off. For
When
lack
the
of
ad
work.
is still on
Yeah, while
Indeed.
their replacement
By the way,
is
right,
still on
by the way, that is
Indeed.
still on Indeed.
The ad's
Anyway, I
still there.
digress. All this is very,
Oh, man.
you know.
No, but
So,
then
what should Elyna say about
Yes.
previous employees
What's a
other
proper
than
response?
they are not fucking eligible
you're
for
yelling.
rehire?
You're yelling.
I always tell people, try to avoid those questions.
I mean,
Say, I'm sorry.
I'm sorry.
You've gotten the receptionist. This is the answering service.
Do-do-do.
no hablo
The
inglés.
number you have reached is no longer in service.
Look, I mean, look, there are a lot of things that can trip an employer up. I would listen. I would say I always tell people to give as neutral a reference as possible. I don't see a reason to go ripping the hell out of them unless there's just
Tammy
something
with
great.
feet praise.
Yeah.
is what I call that.
Well, here's the thing. As an employer, you can get in trouble for all kinds of reasons. Listen, you can get arguably in trouble for pulling a severance offer off the table if an employee could prove that you are doing it for a let's say racially improper basis. In other words, if there's 100 employees to whom you've offered severance agreements, and suddenly they show that of the 100 employees, 20 are African American, and you pulled 16 of them off the table, but you pulled no severance agreements off the table for any of the white employees.
Got you.
That's arguably a, so the point is, as an employer, there's lots of places where you can trip up. And so, can you be candid in that situation? Sure you can be. You can say, no, she wasn't employee of the month. We fired her because she's the worst employee we ever had.
I can say that.
You can
allegedly.
Say that. Supposedly. You can. I
now
think
the question is whether you should.
Yeah, I tend to be. Now, to return to, remember I said put a pin in something?
Yeah.
You said, can I fire a pregnant employee? Yes, you can. But again, I always caution employers, just know what you're doing going into it. Same advice I give here, which is, look, the way I look at it is, let's say somebody, this happens all the time. Somebody says, well, I was about to fire that employee. I mean, we were getting ready. We had everything in place. We're going to fire that employee. But then this morning she tells me she's pregnant. What do I do?
And I hate to say that, but that's the scenario I was thinking of. I'm not sitting here thinking, okay, someone's pregnant, fuck it, they're out. That's not at all, as an employer, that's not where you come from. That's not the place most employers who are well-meaning do not come from that place. But I've absolutely had a scenario where I wonder if I could get in trouble because they might come back at me with a discrimination suit, with anything like that, when I have very legitimate reasons for letting them go.
They can. It's a complicated question. What I usually tell people is, what is your appetite for,
For the record, I have an employee on maternity leave.
What is your litigation tolerance?
You're not getting fired. Don't worry.
Yeah.
Okay.
Generally what I tell people is, look, you have to assess each situation. So if the employee is just not a great employee, and you could have gutted it out, and then if she tells you she's pregnant that morning, I would say you have to consider that, because look, the proximity between the time that she told you she's pregnant, and it doesn't have to be pregnancy, it can be anything, but the time she told you she's pregnant and the time that you made the firing decision is going to be a factor in determining whether that was what motivated your decision. On the other hand, you've got some people that are horrible. They are toxic in the workplace, and they're dragging down the morale of your workforce, and they're causing your business to suffer. So in that instance, what do you do as an employer? You said, okay, well, I didn't expect it. We were ready to fire her, but this morning she tells us she's pregnant. Here's all the reasons why we're going to fire her. What do we do? And the answer is, if it's that kind of toxic...
Have the file. I'm kidding.
I'm not an employment lawyer.
Hopefully you got everything in place already. The answer is, you got to protect your business. You protect your business. Can you wind up facing a lawsuit? Yes, and you will have to defend that lawsuit. You go into it knowing this is a decision you have to make. But if you've decided that this person is toxic and they're really hurting your business, you may have to take action to protect your business, even if you may have to face a lawsuit. And by the way, there's a million things that happen in lawsuits. Many times, I'll give you a different example. Sometimes someone will say, I need to take Family Medical Leave Act time. So, but, interestingly, we've had a bunch of situations where somebody asks for that leave when there's actually been a decision made to fire that person prior to them requesting the leave.
Of course there is. That's surprising.
And so if they sue, you can show, and sometimes you can win and not even have to go to trial. You can show that decision had been made, and so it hadn't been communicated yet because circumstances, took it a different way.
On Friday.
Hello. But that decision had been made, and this matter is ended as of this moment, and courts will agree. So there's a million things that can happen, but what I always tell people is, you got to protect your business. So if you think this person is really toxic, the fact that they announced to you that morning that they have this condition, that condition, they have a pregnancy, whatever, that can't stop you from taking the action that you feel like you need to take.
I joke about the pregnancy, but really it goes for anything, right? Like if someone says tomorrow they feel uncomfortable because they're the only African-American employee, and that person is so beyond toxic that you decided to fire them. Like, I'm not going to lie, as an employer, I would hesitate. I would absolutely sit and hesitate, even though it is not, it wouldn't be racially motivated from my end, but they're going to question it, right? And I think if it were the other way around and I was the employee, I would question it too. I think I would. Sure. So I do see the other side, but
I will tell you what happens in a lot of these cases is, well, that's the instance you might want to use a severance agreement. But a lot of times what happens in these severance agreements is you do get a certain period of time to consider them, and a good severance agreement will tell you up at the top or in bold language, we encourage you to take it to an attorney and talk to an attorney.
Sure.
And a lot of times what will happen is, the attorney will take it and then write a letter to the employer and say, look, we're not rejecting your offer. We're within the time. We're not rejecting your offer, but we have serious questions about, the reasons why so-and-so was fired, and we think we need to open a dialogue. here's some documents that we think we need. You don't have to give them to us. We're pre-litigation. But obviously, if we wind up in a spot, whether we're in front of an administrative agency like the EEOC, or if we wind up in a spot in front of a court, you're going to have to give me those documents. I think you should do it now so we can try to expedite these matters and see if we can come to an amicable resolution. And in the meantime, make sure you preserve all your documents. Don't destroy anything. So, many times when that happens, the employer will come back and say, all right, well, I don't think you're right about this, but let's talk about it. What is it you're looking for? We'll keep this offer open, so you don't have to worry about the 21-day period expiring and us pulling it off the table. We'll keep the offer open while we're talking. Let's discuss a resolution. And then many times you can actually work something out with them where it ends after a negotiated, period of time and a negotiated settlement. So there's a lot of ways that things can go as an employer. There's a lot of options and tools that you have, but employees have some power too. That's the way it goes. There it goes. I know it's terrible.
Oh.
I know.
I have sympathy on the other side.
I do too. Like I said, my heart is in one place, my business is in another.
I have sympathy on the other, because I do think there's a lot of fucked up shit that goes on too.
No doubt about it. No doubt about it. I gotta tell you.
After 8 years of having a firm,
there's
fucked up shit that goes on is the understatement of the year.
Okay, but to be fair,
she drove one of my associates home. Just kidding. Block that out.
Tell the story.
No,
we're gonna tell a story.
We're not going there.
Let me tell you this. Look, there are terrible.
I'm always the designated driver.
Yeah. Designated driver. When attorneys don't know how to act, they get
there are definitely
wasted and pass out on the floor of a networking event, and I'm home sleeping, and I have text messages going, "Your associate had to be driven home by me," and I'm going, "Oh my fucking god!" Like, okay.
So one of the things I researched years ago, just to give you an example of how bad things can be. Okay, this is the worst example. Because I think we had a case
tell
where...
us a horror story.
This is not my case.
Tell us what you
This is not my case. But we were researching... Somebody had alleged what's called a hostile work environment against one of my clients. Hostile work environment. So it is hard to prove a hostile work environment. So I was researching the kind of things it would take in order to qualify as a hostile work environment. Here's the one that I came up with. There was a case back in, I believe, the 80s. It was in Alabama, so you know where this is going. It was at a factory. There were a group of African American workers and there were a group of white American workers. The supervisors told the African American workers that they all had to take their breaks at the same time, as a group. So when the African American workers would, as a group, get on break and they would go into the break room, all the white employees that were in the break room would leave the break room at the same time, and for months on end, when the African American workers got into the break room, there were nooses hanging from the ceiling. That is a hostile work environment.
Oh my god.
It is.
That's a hostile work environment. Things below that level, it is very hard to prove hostile work environment, which is why I say when you're talking about what I call small employment law, which is, the individual cases, largely in two buckets, wage and hour in one, employment discrimination in the other. Wage and hour is, I'm not going to say fish in a barrel, but there's a reason why there are a lot of lawyers on the plaintiff side.
There's a reason why there's billboards
clustered. Yeah, there's a reason why
Right.
On the employment discrimination side, it is hard. It is a heavy lift. That one gets there in abundance. That one crosses the line clearly. But there's a million cases where you're not really going to be able to prove discrimination.
Right.
It's ambiguous enough. It's debatable
it's hard to
enough.
show intent, right?
It is hard to show intent.
It's
absolutely.
very hard to show the intent of the employer. How do you, even if they did have a malintent, how do you show?
Well, and look, and the truth of the matter is, a lot of times,
like a memo in the file that says, "Fuck this Hispanic guy."
Well,
how else do you prove?
Yeah, exactly. But
in Miami, if you fuck this white guy, hello.
Discrimination.
So
these white people don't understand our culture.
Feel left out.
Yeah.
You feel left out.
And Layton's shaking his
I'm not going to tell you some more stories on this
He's
subject.
like, no comment. No comment.
But let me say this too. In a lot of these cases, though, a lot of times an employee will sue and really they do not. I can't say how often this happens, but they don't really believe in their hearts, I don't think, that there's discrimination.
Right.
What they feel is, hey, I've worked at this place. I understand this feeling. I've worked at this place for a long time. These guys me by
Right.
just summarily
Whatever it
letting me
was.
go.
Yeah.
There was no opportunity to correct. They just let me go. I feel really aggrieved and angry about this. And so somebody has said, that maybe because I'm Hispanic or because I'm Jewish, or whatever. And so they bring a claim. That is an instance that should be screened out, and that's the reason why there are some serious hurdles that are put in the way of these kinds of actions, and you really do have to prove a lot of stuff. And so those are not easy to prove. And so there are definitely lawyers, very good lawyers in that area who practice this kind of law, but it's harder to find one that's going to take those kind of cases.
Because who's paying for this circus?
Well, plaintiffs' lawyers pay for these. Plaintiffs' lawyers pay. I mean, if somebody takes that kind of a case, they are essentially
then
agreeing.
they think that's a good case.
Yeah, they've got it. Yeah, they've really got to buy that case. Yeah,
right?
But so there's attorney's fees in that statute too, if you can actually prove the discrimination.
if you win. Yeah, if you win.
As opposed to the 2 hours that the employee was owed, and
That's
and I get $800,000 for going to trial.
That's
on this
exactly
bullshit.
it.
Okay.
Yeah, those cases are. I'm not going to say it's a volume business.
Shysters.
I can say that.
Shyster
You
lawyers.
said it, Leslie.
I'm kidding.
You said
This has
Marko.
never happened to me, by the way.
But again, there is a reason why, and it's based on the way the law is set up.
Yeah.
There is and the presumptions that are created in the law.
There's a motivation
There's a
in the
reason
law
why- yeah.
for lawyers to want to help the client that is owed the 2 hours late.
There are certain areas of the law, let me clean that up. There are certain areas of the law where there are a reason why lawyers flock to those areas.
Of course.
And this is one of
Nobody
those.
works for free.
Right.
This ain't community service.
This is one of those
I
areas.
love my clients. I don't work for free.
This is one of those areas where lawyers flock to it. And look, you can understand why. The law is set up in a way that makes that a fruitful area. Employment discrimination much harder.
Word.
He
So-
tends to sound such a good lawyer. He's just such a good lawyer.
So
It's a fruitful area. Thank you, Dan. The ambulance chasers all go to this area. Go on.
I'll tell you what interesting. I'll tell you an
Leslie
interesting.
Shyster.
Yeah. I'll tell you an interesting area. What's interesting to me is COVID, which is obviously a once in a generation, once in a lifetime experience. We hope. Let's hope. Let's hope no smallpox get out of the community.
It's give or take every 100 years.
Give or take. So there was a lot of litigation that pushed through the system and is still pushing through the system on COVID cases. They kind of waned. It's not quite what it once was. But like some of those cases are, hey, I had COVID and I believe I was fired for. That's an interesting area that is.
You believe you're fired for what?
Like not showing up to
you
work
don't show
for 2
up
weeks.
to work because you have COVID.
Yeah.
For a couple weeks?
Yeah.
It's the thing with COVID is
But
that
not every
Where
employer.
wait, I want to
Hold
know where
on.
these employers have so many great employees, they can go, oh, you didn't show up for 2 weeks, I'm firing
No,
you.
but
I mean,
hold on.
I can't find enough good people to
Wait,
begin with. I'm not
wait,
firing nobody unless they're a
wait.
fucking train wreck.
You hear
Hold
that,
on.
everybody?
I
These
was
are
actually
a great team.
I was going to disagree with you and go the exact opposite direction. I was going to say I can absolutely envision a world where I'm a mom and pop shop with one guy at the counter, let's say a restaurant, and if that guy gets COVID for 3 weeks, I'm out of business.
Yeah, well, good luck finding a replacement in this economy.
Well, I mean, I'm hiring.
You gotta
whatever
put up
fucking
with
Joe
COVID,
Schmo.
smallpox,
No,
and any
listen.
other bullshit they come up with.
I'm coming up with whatever Joe Schmo walks through the fucking door because otherwise
Well,
I'm out of business.
oh, man.
And when
I
you
get
come
it.
back in 3 weeks, your job ain't here. Because I
Oh
have to
my
hire
God.
someone to serve
I feel
tables.
like this whole thing has shifted to the point where I will put up with so much bullshit because, like, replacing someone that is decent, impossible.
Well, issues arise in this area.
He's
It's all
like,
changed.
well, I'm not gonna
What
comment on any of
if
that
they
shit.
have long COVID for like 3
Well,
months?
that's it.
What the fuck
That's
is
it.
long COVID?
That's when the COVID lasts and lasts
That
and
is it.
lasts, and it's the gift that keeps on giving.
Well, I think what's interesting about this is
COVID doesn't exist.
This is
Ron
a-
DeSantis.
Stop it. Stop. So this is a good example of how
Did you say Ron DeSantis cured it? Is that what
He's saying that's what he said.
he cured it.
It's done.
It's like Al Gore back to the internet. Is that what we're doing? Okay, all right.
So this is a good example of how like these old concepts get like updated all the time. So COVID is a good example of that. So if you have COVID for a relatively short period of time, because we know COVID now has it can be like a flu. It's not a flu, but it can be like a flu. So you can have it and it's gone. There are people that have long COVID, and long COVID can be, for example, a disability. So if you have long COVID and you have brain fog as a result and other debilitating conditions, you really can claim and say legitimately that you have a disability. There's a lot of people that have COVID for a couple of weeks, and that probably does not qualify I say probably because, there's always questions in law.
Yeah.
But probably that is not let's say, a disability where you'd have
Sure.
to give somebody an accommodation because under the ADA, because that is a condition that remedies itself and you get back to being made whole. But if you have it for, years because you've got like degenerative conditions that set in or something like that, then it may be a different story. So it's always a field that's changing in that regard. I don't know how we got onto that, but I see Leslie looking at me like, oh, really?
That's a great topic.
Oh, really?
Such a bullshit if I've ever heard it.
It's funny. Leslie was looking at me with the same expression that people have looked at me in mediation when I'm like reading them the facts of life, right? And they'll look at me like, oh yeah, college boy. Oh yeah, smart guy.
Sure,
oh, yeah.
sure.
Oh yeah. Come after me. Okay. All right. Well, so be it. So be it. We will.
Right. So be it.
What are you gonna do? Your choice.
Right. Your client's paying. I mean,
let's go.
fuck it.
Well, but listen, so coming full circle to the maternity thing and pregnancy, I feel like some of these arguments would apply though in this situation, no? Same as maternity leave. There's exceptions for depending on the size of the employer, right? Because I can see, like, coming back to my example of this mom and pop shop, you get pregnant and or you have long COVID for 3 months. Either way, you're going to take 3 months off for whatever legitimate reason that you need to take 3 months off. Absolute maternity is a legitimate reason, but so is long COVID, frankly. I hear that.
Sure.
So if you're a mom and pop shop, you can't just not have that person for 3 months, right? Like, that's hard. It's going to shut down your business.
That's hard.
I mean, I'm serious.
Yeah.
Like, you're fucked,
Yes.
And so there are some businesses that can make it work, but there are some businesses that are not going to be able to make that work. And so what do? You replace them, you move on. So shouldn't there be the same kind of exceptions that there are? And I use maternity because it's a long established conversation, I think, where, if you're an employer of 10,000 people, probably not going to be okay to say, peace out, we need you so bad that you can't have your maternity leave.
Yeah.
But if you're an employer of 3 people, like, you're destroying a business by disappearing for 3 months, even if you're absolutely in a legitimate place in requesting it, right?
I mean, there's something to be
Yes.
Hold
No,
on.
I mean, I feel like the COVID arguments need to go the same direction, though. There needs to be a happy medium.
They're all evolved. The COVID arguments are all evolving, but the law. And I've seen a lot of cases that I have litigated this recently, and ongoing. So there are a lot of cases that cut a lot of different ways because people are still finding out where things are.
Right.
But generally speaking, I do think that's kind of where the law is going, at least in terms of that. Because remember, there's different ways to sue. You can sue under the ADA, you can sue under other things.
Right.
But a lot of people sue under the ADA. They say, look, you should have given me an accommodation because here I am having COVID, this once in a lifetime pandemic.
Right.
So the way the law is evolving in that area is basically what I was saying before, which is if you have COVID for a relatively short period of time, you get it, it hits you like a flu.
Yeah, whatever.
You get it for 2 weeks, you get
it's
better.
Like you're sick, you got the flu.
Yeah, there may be a host of other things that you can claim, but in terms of a disability, that doesn't walk and talk like disability.
You diarrhea for 3 days, you come back.
Exactly.
Yeah.
But now if you have it where it's going to last for years and it's going to be something that has implications that we don't even yet understand, then it could qualify as, let's say, a disability. You might need to give somebody an accommodation for it. Complicated area, and it's also complicated because we don't know where the ground is on it. I mean, even though thankfully we have vaccines and whatever, but I mean, we still don't know where everything comes to rest with respect to COVID-19. So it's kind of hard to predict exactly where the law is going to be on it. But basically, that's kind of where it's coming out. Short-term COVID, what we've experienced as kind of flu adjacent. You get better, not a disability. Serious matter where it's going to affect you for years and years, arguably disability. That's basically the message.
So you mentioned accommodations. I have to ask because I know it wasn't one of the things we previously discussed, but tell me about accommodations. How much do I need to accommodate?
Well, first of all, you have to. Well, if we're talking about the ADA, first of all, you have to decide whether somebody has a disability, and that's a complicated question. There are
does it have to be only for a disability?
Well, under the ADA, it does. I mean, there are easy cases. I mean, somebody that's in a wheelchair and ambulatory issues exist. That's a disability. Somebody that has, I mean, you know what a disability is. It's almost like the old Supreme Court line where I can't define pornography, but I know what
I know what I'm seeing. Judge Hand.
Yeah, that's right. Lawrence. So there are certain indisputable matters of disability, but there's a lot of areas where disability is more subjective. It's harder to tell. Alcoholism is one example. Sometimes that's a disability.
Oh my God. Oh my God.
Sometimes it is.
Talk about the wrinkles.
Oh my God. So there.
You want me to go on? Oh my God.
Come on, Leslie. Come on.
Oh my God.
There are examples of more complicated scenarios.
being drunk is not a disability. Is what Leslie is saying.
Leslie's about
He's here
to
to fill your
go.
cup.
Yeah.
Okay.
We need to refill this delicious coffee.
Yeah.
No,
Delicious,
we're not doing
delicious
it.
coffee
We're not
right
doing
now.
So, the first order of business is to decide whether somebody has a disability. Assuming the answer is yes, then you would have to offer them a reasonable accommodation. There are certain jobs where that's not possible.
Correct.
There's bona fide occupational qualifications. There's things where you just can't, there's no way around it. But if you can, then, usually you do. So let's say, for example, there are 2 phases to your job. One phase is being out in the workforce, in the community, moving around, driving, walking, and so forth, and the other is back office. And let's say somebody is reasonably proficient at both jobs, you have a need for both positions, and they suffer a condition where they no longer can walk around very much.
Narcolepsy.
Yes, narcolepsy. I was gonna go for wheelchair bound, but narcolepsy is fine. So there's a condition where they can't walk around a lot.
Well, I'm picturing someone just falling asleep on their computer. If they fall asleep on their computer all the time, do I need to accommodate that?
I'm gonna answer that question in a second.
Hours.
Let me just say this. This is a question on aging, okay? I'm 55 for those out there.
But we're talking about a person with narcolepsy.
I wanted to say that as you get older, you get very fitful sleep. And so sometimes I'll be in my office, which has a glass front, just like this one does. And I made the mistake, that it's a curse and a blessing. I got a Shaquille O'Neal Lazy Boy office chair.
Oh.
And so sometimes I'm so tired, I'll like close my eyes and lean back. And like the people in my office will collect in front of the glass door, and I'll like open my eyes, and there they all are staring at me, and I'll say to them, guys, I'm not a zoo animal. Don't like stand at don't throw scraps of food at me. So narcolepsy.
Well, I can't think of a better example of someone falling asleep while they're doing their job.
Well,
do I have to accommodate this?
Okay.
What type of job is it?
To me, it doesn't matter. Being awake is an essential function of all jobs.
Yeah, but if you can still bill to my KPI, I don't give a fuck what you're doing.
What are you doing? Tapping with your forehead?
I'm gonna gently reroute the conversation from narcolepsy to you have a condition where you're wheelchair bound.
Okay,
so
fine.
if you're wheelchair bound,
But that's an easy one.
Well, okay. But if
you
you suddenly became wheelchair bound, okay, and now it's a serious condition, it's gonna last you for a long time. It's not like a 2-week thing. Now, if you go to the employer and you say, listen, I'm no longer able to do the walking part of the job as easily, so now would you accommodate me by giving me a position back office where I can perform all the essential functions, but I don't have to be walking around in the community? Generally speaking, if you have a position to give and other boxes are checked off, you'd say, yes, that person should be given a reasonable accommodation. Now, narcolepsy is a little different.
I don't see a problem with the narcolepsy. You'll eventually wake up, right? I mean, and you can resume researching and writing my memorandums and billing the file.
I'm being real though. Like, how do you perform any job if you have narcolepsy? They fall asleep.
I mean, but don't they fall asleep for like 10 minutes and wake the fuck back up?
Imagine that you're in a client meeting and your associate over asleep.
Okay, they
for
no
10
longer
minutes
have a
suddenly.
client-facing job. All right.
You know what?
I'll give you a better example. Tourette's, which is a very real condition.
Oh, God.
And people have different, people have differing levels of Tourette's. Sometimes it's just switching. I'm aware of what Tourette's is.
Yes.
Sometimes it's totally not a problem. You can accommodate.
I think Mandy has
but in a very, very severe.
Mandy does this weird, like,
totally fine.
So did
I
Jesse.
get it. That doesn't affect your work performance. I'm with you. But in a very, very severe Tourette's, like someone.
Well, then you can't do the job.
That's my
You're
point.
fired.
That's my point.
Can I fire them, Dan?
Well, that's my point. Is do you have to accommodate
They
that?
can't do their
I
job.
mean, if you have a client meeting,
There's
suddenly your
one
associate
job.
says, shit, fuck, motherfucker. Like, what do you
Okay,
do?
This is
What
the
do
job. This is the job description.
I would suggest.
This is the KPI to this job. You can no longer do
I want
this
to hear
job.
Dan's answer.
Well, the answer is, I mean, look, if there's only one job and it requires you to not be screaming at somebody
I mean, they could be the receptionist, I guess.
then I mean, you may have to.
The
you
bill
may have to
collector
take
is
that
allowed to keep.
But look, I mean, that is a classic example of where you would try your best to offer an accommodation
Like a
because
back office.
yeah, because this is
What are you, a
because-
file clerk? You went from lawyer to file clerk? Is that reasonable?
Oh, look, well, no.
I need you to scan.
I mean,
make copies,
As
and
far-
make binders.
as far as
You'd be a
lawyers
service
go,
partner. Don't
Don't
talk to anybody. Just sit back in the office.
This
and-
is one of
I
the
used to do
jobs
that years
people
ago.
with trust could keep as lawyer, right? Like we
Absolutely.
people all the time anyway. Like,
Yeah, I curse all
They'll
the
be head
time.
of my litigation department.
Our podcast is called Lost Shit You Should Know.
The truth is, I'm shocked. It's now 53 minutes into the conversation. I haven't cursed once.
Really?
Yeah.
This is-
I curse all the time.
This is not okay, Dan.
I make it a point of
This
pride
is
to
not
curse all the time.
okay.
I'll find a
Anyways, all right,
reason to.
so the answer is you try. It sounds like that
It's
was
just you
The
wait,
answer is you
put in your
try.
file
The
how
answer
much
is-
you tried.
It depends.
It depends. It depends. And
Thank
you
you,
tried. And you try. And I go back to, guys, I don't know what world this employment law is living in. These days, it's so hard to find good employees that even if you have Tourette's and you say crazy shit every now and then, you're still fine. I cannot fire you.
I actually
You're gonna
saw.
continue working.
I actually saw this
Okay?
morning. I actually saw
What
this
the
morning
fuck?
that the unemployment rate ticked up to 3.8, but that's still. I mean, that's like 96%.
everyone is employed. Dan. Anyone that wants a job is fucking employed. It doesn't matter how bad they are of an employee. Like, I just can't.
There are no bad
Well-
employees. There's only coaching opportunities.
That's so
Leslie.
adorable.
You know what's
That's so
interesting?
cute.
You know what's interesting is because there's such good employment now and the economy is kind of strong, you're actually seeing some unionization efforts, and you're actually seeing strikes. And
What?
this is
What?
yeah. This is
Yeah,
this
but
is
with
something.
people.
This
Hold
is
on.
something
Yeah,
that
but
last-
with
Unions. This is a great topic. Let's talk unions.
I do not do union work, okay?
He's like,
but
no.
But let me say this. That, you know, in the 90s, in the 80s, I mean, you didn't
How do
see
you
this.
feel about you? How do you feel about dead puppies? I'm just trying to get as bad as we can here.
If they get the job done, they're fine. You know, you didn't see that kind of activity for a long, long time, and now you're starting to see.
Wait, who's
you know,
trying to
people
unionize?
organize?
The baristas.
Baristas are a good example.
The fuck are you talking about? You make coffee.
How do you unionize?
Absolutely.
You're
the
kidding.
baristas are unionizing. Yeah.
What is that?
Some are. Not if you break the union.
Leslie's officially
Oh my God.
speechless.
Oh my God, it's hot in this office today. The fucking coffee makers.
Just remember, it's Leslie that said that. The next time she goes to a Starbucks,
All hate
not
mail,
me.
please send to Leslie.
Yeah.
Leslie, I trust counsel.
Exactly.
What the fuck? Wow, guys, I have nothing to say about that. I'm gonna take advice from counsel and shut my fucking mouth.
Excellent. We have learned that on this podcast. Listen to your attorney. Number one rule we have learned from filming this podcast.
No, the number one rule is clean up my hair in your editing process, and the number two rule is listen to your
Okay,
attorney.
so let's switch topics here because I want to talk about this. Let's talk about Leslie's ideal scenario, which is we have no employees and we've replaced them all with computers.
Well, the ChatGPT thing, yeah.
So is ChatGPT taking over the world?
No.
Will we all have jobs?
No, yeah, you'll have jobs. Yeah. Look, the ChatGPT thing is there's a lot of people who are like invested in making ChatGPT an employment law topic. I'm not sure it really is. Let me say this though. ChatGPT is more of it is an absorption device. In other words, it sucks in information and that's how it learns, okay?
Sure.
So there are some people that are talking about using ChatGPT in employment contexts to either like write job descriptions or
I've done that. I've actually done that.
There you go. So now,
But not just that, but and it doesn't have to be ChatGPT, just AI in general,
Yeah,
right?
yeah,
There's lots of
general,
software out there.
yeah.
But there's absolutely, I have heard of companies, large companies, already starting to screen resumes with AI to get through first round of resumes for people that put up a job posting and you get like
interesting.
10,000
Right.
employees nationwide.
Right.
We're talking about big companies, right? But I can absolutely see. I mean, I'm a Joe Schmo tiny business, and I can tell you that when we put up an ad for receptionist a couple months ago, I think we had like over 100 people apply.
Yeah.
And we had to sit there reading all these resumes. And if I had like a click of a button that could tell me, hey, these 54 people are not qualified, and at least we've narrowed it down to 46.
okay, now you've isolated the issue. I'm not sure the issue. I'm not sure how much of a real issue it is, but that's the issue.
Tell me.
The issue is that
That takes hours
that
to go
AI
through, right?
is
I
AI
mean-
is only as good as the inputs that it gets. So in other words, if you, let's say you have a very professional, very responsible person putting in the criteria, teaching the AI things, and then based on that very responsible person, the AI is making decisions like first level screening for job applicants.
Sure.
No problem. Now, flip the scenario. Let's say you've got the Grand Wizard of the KKK, who is inputting
Was
the
he a good
information.
receptionist?
Yeah. let's say that's the person that is
He
feeding.
doesn't have narcolepsy.
Yeah. Let's say that's the person that is feeding the information into ChatGPT, and then lo and behold,
The qualified applicants.
out of the 100 applications you get, you're only getting the 3 white people that whatever. So the point is, so
Not the ones named Tyrone. None of those are
Okay.
screened out.
Okay, Leslie.
Is that what we're saying?
I'm saying is-
I'm saying is that the concern?
Yes,
that
that
you
is-
would actually
yes.
put in
The
the
concern
criteria
is-
that has
Yeah.
no Marias, no Jose's,
Right.
That is a
no
concern.
Right.
whatever.
No, Elyna
Well,
Magolnick
it's-
Santana.
No Elyna Santana, especially not Elyna with an E.
Elyna
That's
with an
some
E.
Russian
That's like
bitch.
Russian
Like,
communist
yeah, some
shit,
Russian
like-
communist shit. Like,
That's an interesting. That's actually an
Russian
interesting question.
influence in
Let me
Cuba.
say-
That's bad.
That's actually an interesting question.
I
Here's
never
why.
even thought of this.
Because remember, there's 2 different ways you can discriminate. Okay.
Right.
One way you can discriminate is by what we call a disparate treatment, where you're basically saying, I don't like you because you're black. I don't
Right,
like you because you're
right.
Jewish. I don't like you because you're a woman.
Like big picture, like
Well,
more,
it's a very direct
more
discrimination.
like
Direct. It's
Very
direct.
direct.
David Levine's ain't getting through this chat GBT.
Okay, because of the Jewish
We love
thing, yes.
David Levine.
Yeah.
David Levine will be visiting our podcast.
Yeah, he will.
Anyway, go on.
So that probably will not be an issue for ChatGPT because there's no real way to teach it that unless you're saying don't screen out the Jewish names.
No more
Right,
Levine.
right.
No, like my
No,
Leighton
I hear
is
you. It's
Leighton is
very
my last
direct.
name,
No,
but
Rosenberg.
Very direct
Leighton is my last
discrimination,
name, but originally was Leibowitz.
Overt.
So
Right,
very
yeah, screen out the
overt,
Leibowitz is
direct.
better.
Very overt,
Now,
direct.
there is another
Interesting.
area of employment discrimination, which is a disparate impact, which means
Right.
that you're not
The bias
necessarily
will make it
saying,
different,
yeah,
right?
you're not necessarily saying
Much
if
more-
you're Jewish you're out, but you are
Right.
setting things up in a way that,
That
you
it's
wind up
obvious.
with, you wind up with a population
Correct.
that is
Sure.
inherently discriminatory.
Right.
So that is probably the bigger concern with
Like,
ChatGPT.
like
that
not
you're,
the zip code or not this.
exactly. You're
you
putting
know,
in
like,
information that winds
only
up with a
people within the
picture.
radius of by Coral Gables' office that's this big.
Now,
Sure.
look,
You know, like,
wow, I
that
never
is
thought
all
of
an
this, guys.
that's all an emerging
That's
concern. I'm not sure it's an actual concern yet. I think it's drawing attention because it's a neat new area and
Yeah,
it's
yeah.
and people that
Shiny object.
and people that consider themselves, I love this term, thought leaders, love to like jump into this area and write columns about it. ChatGPT is inherently problematic though. I would be very cautious if I were an employer or anybody else to use ChatGPT. I'm gonna give you an example why, but it comes from the legal community,
Well, wait,
not
pause.
from.
But you're talking about using ChatGPT for employment things.
Yeah.
Or just
Yeah.
in general.
No, I'm
'Cause I
talking.
use that shit every day.
I'm talking in general. Okay, so now I'm talking to you, Ellie. Let me tell you why. I don't know if you've heard of this case, okay? But now
I
I'm
wrote
gonna
an email to a client yesterday that I
Okay.
ran through
Okay.
how to say X, Y, and Z to a client nicely
I will say
without
this.
cursing them out.
This is, I will grant you, Ellie, this is attenuated to the issue of, this is distant from the issue of employment law.
Sure.
But it is a reason to be a little cautious of AI. Let
Tell
me give
me.
you one. In New York,
But
there
I'm a
was
thought leader,
recently.
Dan.
I know that. In New York, there was a recent case where some poor associate at a firm.
Oh, sure. I saw this.
Yeah.
Yeah.
So they used ChatGPT to develop a brief.
Yep.
Okay. So they fed in the facts and they said, "Give me cases that say the following," and they got a list of cases with the propositions of law. They then used that in the brief.
Like case sites and stuff.
Case sites and stuff. Yeah.
They were
So.
good.
Yeah. Okay.
What?
So it gets worse. It gets worse. So they filed
read
this
about
brief.
Where'd they
okay.
get it?
They filed this brief with the case citations that ChatGPT spit out at them.
It was a wonderful brief.
Smith v. State of
Great brief.
Florida. Like,
So
brief.
now
Case sites.
the
AI
yes,
did an
correct.
amazing brief.
So now the other side responds and they say, Your Honor, in writing, they say, Your Honor, we have run this through Westlaw,
We
and
can't find
these
this case."
these don't appear to be cases.
These are
And
made
so
up
the
cases.
court issues what's called an order to show cause, where it says, okay, first party that filed this brief, give us the cases. So the lawyer goes back to ChatGPT and says, okay, you've given us these case citations, I need the cases. Sure enough, they get cases.
Oh, yeah.
Written opinions. ChatGPT generated
ChatGPT created
They
Smith
generated
versus
them.
Florida.
and they then
Yeah,
then
absolutely.
submitted these to court saying,
100%.
okay,
ChatGPT knows how to cover itself up.
Brilliant. No, but
it's very close to like HAL in that movie, 2001: A Space Odyssey. So they file these things, and the other side comes back and says,
These
aren't
still
cases.
don't exist.
And the other side, I believe, said, not only are these not cases, when this case says it comes from the 11th Circuit, we actually called the clerk of the 11th Circuit Court of Appeals and said, we're being confronted with this case that purports to come from your court, doesn't. And they came back and said, no, it does not. So And the lawyer then faced sanctions. I don't know what happened to the lawyer.
Yes,
God
yeah.
help him.
Hot mess.
I hope that, yeah, it was a hot mess.
But
So
God
the
help
point
him.
is that you've got to be extremely cautious because ChatGPT is designed to, and this doesn't even get into, by the way, the first article I ever read about ChatGPT was a New York Times columnist who wanted to test the limits of it. So it started a conversation with ChatGPT about business matters, and about 2 hours into the conversation, ChatGPT tried to get him to break up his marriage and marry the ChatGPT.
Oh, excellent.
Yeah. So
I mean, here I feel
ChatGPT.
better.
I think the point is that ChatGPT is set up, as I understand it, to try to fulfill your answer your
It's a
requests.
people pleaser.
It's a people pleaser.
It's a people pleaser. It's going to tell you what you want to hear.
And so if you ask it for a case, it's going to give you a case.
And
Not
it's gonna
just
make
that,
one
it's
up.
crawling the internet and it's
Exactly.
creating content.
But I thought it was crawling the internet for real shit, not shit. It just
It is, but it's
Smith versus
no,
Walker.
no. It's
No.
creating based on what it's learned. So I say that I use it all the time. I don't use it to write briefs, for the record.
It's just like allegedly.
Oh, really?
No, I really don't. I have not. I actually have plugged in a couple legal questions just to see. I used it as an example at one of my networking events, and I was very impressed that it always ends with "Please discuss with a lawyer," as this is a complicated area.
Oh,
That is like
excellent.
the default language at the end of any legal question you
Okay.
ask it. But apart from that, I use it every day. As a matter of fact, I have it on my home screen on my phone. Like I use it constantly for all kinds
There's
of
an
things.
app.
No, yeah, there's an app, and I'll
There's
tell
an
you
app.
why. What I do use it for, which I love and I think it's wonderful, is I use it for random shit every day, like social media posts. Like if I make a social media post now, like write me a social media post under 70 words so that it fits on the Twitter or the X or whatever the fuck it's called now. Under 70 words that says, we're launching a podcast, everyone should be excited. And it'll like bring them up and give you like this perfect little thing with like emojis and it's super cute. And you cut, paste, tag with the picture. Works great. I'm telling you, this works.
Wild.
No, it's wonderful.
You're giving me nightmares.
I
You're
know.
giving me
I
nightmares.
know. I do meme creation on it. Like I'll tell it like, give me a funny meme about coffee, and it won't create images, but it'll tell you funny meme about coffee. Girl holding a coffee cup, and it says the tagline is blah 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 blah, and then I can go like meme generate that shit, and I do it all the time as part of our marketing efforts. I also use it to write emails. I'm very careful not to give it confidential information, not to give it any like client confidential information.
That's the biggest
Yeah,
issue.
I'm very
Yeah,
careful about it.
that's-
I'm very careful not to step over the line of the things that I think are legal work. However, I use it all the time for like, tell me how to tell a client, fuck you, you're wrong, in a polite way. Like, and it'll give me, like,
You're wrong, does it
like,
work?
No, like, fuck you, you can't have a refund, right? Like, in a nice way. And it'll give you 2 sentences on like, very like, I appreciate that you are disgruntled by our communication, like whatever the fuck.
Yeah,
like,
yeah.
Or you're lying to us, fucker, like you need to tell us the truth in a very nice way. And it'll write you 2 sentences in the most professional language.
I
and you
really
can
have to
literally
play with this.
copy it.
I
It's
have not.
wonderful.
I have not.
You're better than me. I'm torn on this subject because, in a sense,
I love it.
In a sense, I recognize that it's efficient and it can give you those two. In another sense, I feel very old saying this, but I feel like those old guys yelling at clouds, like my words are perfect. There's no app that's gonna like recreate what I can write in an introduction. Whatever.
And listen, we're not even getting into actually doing legal work, but I was recently at a conference. I was at an immigration law conference, what I do, and there was a bunch of vendors actually showing some new software, like kind of startups and such. I actually signed up for a couple of listservs, startups that are doing things that launch brief writing service.
Yeah.
And so, for example, the one that impressed me the most is you upload the evidence. Like, for example, if I have to write a brief in support of whatever, a waiver or an asylum case, which is something everyone can understand. There's an asylum case, I have to show that they qualify, and there's evidence that I attach. You upload the evidence, they give you a paragraph, you write 4 bullet points or 5 bullet points on what the salient issues are that you want this brief to say, and it creates a brief, an exhibit list already made for you, itemized, numbered, boom, work done. This is a startup, and they're not selling this product yet. But I'm not going to lie to you. I sat there watching that demo, and I was damn impressed.
It was really
I was
good.
damn impressed by the work product.
I gotta tell you what
It was scary. I was scary.
let me say this.
Like, even for me, it crossed the line into, oh shit, computers are taking our jobs. Like, I'm not gonna lie.
So far, I've looked at the computer enhancements as just that, enhancing your job.
Yeah.
I have not looked at the ChatGPT for that function. But I will tell you that I'm giving away trade secrets here. So, but I mean, like Westlaw has this amazing function where you can go into what's called trial court documents.
Sure.
I realize that's nothing to do with employment law and civil litigation, but civil litigation to some degree. So this is what levels the playing field between all lawyers and the civil litigation side. So you can go into a tab called trial court documents, and you can say, all right, Florida, motion to dismiss, standards. This is the easiest example. So you then will get a huge bank of documents that Westlaw has ingested that involve motions to dismiss, where standards, which is usually like the title of a header, where that exists. And then you can start filtering it down. Like I'll filter down from law firms, like my old law firm.
Yeah, absolutely.
And you start, and I put in a list. Proskauer, Weil, Gottschall, Sullivan, Cromwell. And then I will take those results and I'll say, okay. And then, again, it's like 2 a.m, right? I'm not interested in like recreating the wheel here. I don't want to, So I will find a 2023 case where, let's say, a Weil, Gottschall lawyer, great firm, guys. Weil, Gottschall lawyer will like write a blurb on the standards for a motion to dismiss, and I will then take it and update it, and it makes my life easier. I will not be happy, although I recognize this may exist, where I can like input the facts of a case and either a ChatGPT or Westlaw will spit back at me a fully constructed brief. But that would be a bad moment.
That's the moment where the computers become.
Yeah, I know, and then they become sentient. We have a big war. I know.
Wow!
And
it's like Terminator.
That escalated
quickly. Go with iRobot, different generation.
Yeah,
iRobot all over again.
Yeah.
But,
I don't. What is,
yeah, I know, you're lost in space. It's alright. Download the ChatGPT app and test it out. At least then you have a sense of, you know what I've used it for too? Translations. I've asked it to translate for me. It does that damn well.
Absolutely.
Yeah. I've asked it to give me like bullet points. Like the other day I was like, tell me 10 fun immigration facts. And it gave me some
immigration.
Well, I was actually trying to think of ideas for a newsletter.
Yeah.
And so I was using it to help me, like, on the creative side of, like, what can I
brainstorm
write about and brainstorm.
stuff.
I use it to brainstorm things all the time. That's actually probably what I use it the most for. Is to brainstorm where I'm going with things or what I'm thinking.
That actually does sound like it could display some people that work, because, like, people that write blogs for law firm sites, for example, because I hated doing that. I hated writing blog posts. I did it for like 6 months and then said, this is never doing this again. But like there was a whole industry built up where you could find somebody in another country and they would all bid on the right to write your blog post. And now, yes, I can imagine that ChatGPT or whatever can like generate those posts because they're all basic stuff. Like you're not paying somebody to like analyze the new Supreme Court case on a cutting edge issue.
We're not publishing this in a law review. Like, let's be real.
Exactly, right. You're saying 10 things to do if you're pulled over to the side of the road by a cop. Okay, so that would be something that somebody
blow. We learned that.
We learned that in another podcast.
Call your lawyer. Yeah. That reminds me of like a million ads I've seen for lawyers, which are fantastic. None of mine. I don't like advertising.
We're off
lawyer advertising.
But anyways, all right. Well, unfortunately, our time is over. Again, thank you so much for coming.
Dan, we gotta have you back.
We gotta have you back for sure.
This train could continue going off the rails for at least another hour.
Any last-minute words for our listening audience?
No. Listen, this has been my first podcast. I love it. I very much hope that you will.
He's like, I will never do this again.
I swear to you, I've been thinking of like the scene from the movie Brazil in the '80s, where the woman like has like a cellophane pressed against her face, and all the skin pulled. I'm hoping you guys do that to me. To eliminate. No, look, I mean, employment law is always changing. You know, here's the thing: civil litigation is our primary bread and butter, but you know that's just a struggle between people that's existed forever, and you know. So that is what we love to do, represent, let's say, one business owner against the other when things begin to go bad. But in employment law, for such a straightforward set of propositions, you employ somebody, you're supposed to pay them a proper wage, you know, don't discriminate, whatever. For the relatively straightforward nature of those laws, there are a billion nuances, and it is a big minefield for the people that have to operate in that area. So if anybody faces that kind of liability, you know, well, it's not like a networking meeting. I would love to talk to them, but that if somebody faces those kind of questions about liability, that's a lot of what we do for a living. So love to talk to somebody about those areas. Obviously, there's new areas in the law we haven't even had a chance to talk about. So that's anybody that faces those questions, love a chance to talk to them.
Awesome.
I do sound like a networking.
You do. That's okay.
Oh God.
That's all right. Thank you, Dan, for coming, and thank you everyone for watching and listening. And we'll see you next time for our next episode of Law Shit You Should Know. Thank you.
Woohoo!
We didn't get to cover anything.
No, me too. I got out of the Me Too thing.
Come back.